we will go ahead and call the next case. This is People versus Stock. It is also a mini oral argument on the application, which means you both have 15 minutes. Mr. Kierpel, you'll start and you can reserve some of that 15 minutes, but we ask that you try your best to manage your own time. And with that, you may begin.
All right. Thank you, Chief Justice McCormick. Good morning, Justices. Ian Kierpel on behalf of Ms. Stock. And this case here is really a straightforward application of this court's previous case of Fiesel. Both of these cases involve the same statute. They both involve a metabolite, an issue with metabolites, and whether or not that metabolite has any kind of pharmacological effect. Turning to Ms. Stock's case, she was convicted of 2 operating while intoxicated offenses with the presence of controlled substance. The controlled substance that was presented at trial was the cocaine metabolite. And that's what came up in the urine screen and the tox report. And when we're looking at the cocaine metabolite, like this court looked at the marijuana metabolite in Fiesel, we gotta determine, is this thing covered by the statute? Is this metabolite even a controlled substance? And Fiesel is great because Fiesel provides a roadmap to get that determination. One of the things we got to look at was, does the statute even encompass the term metabolite? And much like in Fiesel, where the statute didn't encompass the marijuana metabolite, here, the statute doesn't even talk about metabolites. And then we got to look to, okay, well, can we still consider this, is this even a controlled substance? Should we classify this as a controlled substance? Well, if we're consistent with the federal government, we don't have any kind of federal cases that say cocaine metabolites are, and you look at how they define cocaine, they don't mention metabolite either. So, okay, so let's look at the Controlled Substances Act. Could this thing be classified, this cocaine metabolite be classified as a controlled substance? Well, in Fiesel, what the court was concerned about, this court was concerned about was, all right, is there a pharmacological effect? Does this metabolite cause impairment? Does it any chance for abuse for dependency? Any public health issues involved here? And I presented the court with several cases that talk about, well, the metabolite's the byproduct. It's what the body does when it breaks down the cocaine. It's an after effect. There's no impairment there. There's no pharmacological effect. It's merely just shows there's historical use that sometime in the past, potentially several days later, this person used cocaine, but doesn't mean at the time that this test was done, they were still impaired or even had the cocaine in their system. So if we look at Fiesel, and I think that was very important in Fiesel, where it said, hey, look, the marijuana metabolite here involved in Fiesel, no pharmacological effect. No pharmacological effect. This is not a controlled substance as anticipated by the statute. So this conviction doesn't stand in Fiesel. And in this Ms. Stock's case, Fiesel's on point. The analysis this court ran in Fiesel, they should run the same analysis here to determine if the cocaine metabolite is in fact a controlled substance or should be considered as part of the Controlled Substance Act. And if we follow Fiesel, it just doesn't. There's no pharmacological effect. It merely indicates past use only.
Let me interrupt you, counsel, and see what questions my colleagues have, okay? Thank you. Justice Viviano.
Counsel, I'm not sure I understand your argument. The defendant here is not charged with having a metabolite in his system. The question is whether having a metabolite is properly in your system is properly viewed for cocaine, at least as circumstantial evidence that it was in your that cocaine was in your system, which is something that I think Justice Kavanaugh in his dissent in there acknowledged would be an appropriate use of a metabolite, as circumstantial evidence of a statutory violation, just like this one. Do you take the position that it's not circumstantial evidence that the defendant had cocaine in her system?
Yes, thank you, Justice Viviano. If Ms. Stock was charged with use of cocaine, absolutely yes, but she's charged with operating the vehicle with the presence of a controlled substance in her system. That's what the statute says, and that statute doesn't encompass the metabolite. And as indicated with the cases I cited to, this metabolite could indicate use, historical use. That's what the federal court talked about, the expert in the federal case viewing, historical use. And if we look at Fiesel, and Fiesel got to that point where it said, hey, look, this marijuana metabolite can show up in your system for days, long after any of the effect of the marijuana still has any effect on you. Same thing here.
And Fiesel, I think, with the marijuana metabolite,
Yes.
it had a much longer look back period, which again, I think Justice Kavanaugh believed, and the other dissenters and Derer, who were part of the majority opinion in Fiesel, believed that because the look back period was so long, that there may have been constitutional problems with the interpretation of the statute as it applied to the marijuana, the 11-carboxy THC metabolite. But with a much shorter look back window here, it does not appear to me that we have those similar constitutional concerns. Am I wrong?
No, Your Honor. I think we still have the issue of, do people know if someone ingests cocaine, when can I drive? I think we still have that same issue. Is the look back period going to be 1 day, 2 days, 3 days, 4 days? And certainly science is always improving. And certainly we could get to a point where maybe the prosecution or the state starts plucking their hair follicles when you're at the hospital, and we can get something 90 days. I know Fiesel sort of talked about that danger of, well, what's the cutoff going to be? Is it 5 days, 1 month, 3 years? And I think that's the danger we have here, is there's no clear guidelines to the person. Obviously, if I ingest cocaine and drive, that's a problem. But where's our cutoff? And I think that's the issue, and where some of the constitution issues come into play. There's no clear guidelines on what's illegal and not legal.
All right, thank you, counsel.
Thank you, Justice.
Justice Bernstein?
Yes, counsel, good morning. So I'm just going to kind of follow up on that, and just if you can just succinctly kind of say, is that what you feel the jurisprudential significance of this case is? That basically we have to address the issue that you had talked about? And if this court were to adopt your position, what type of opinion would this court issue in terms of how you would see this position going? How would the opinion be written?
I think the opinion should be written that when you have a statute that says any amount of controlled substance means the controlled substance is in your system, not the byproduct of it, not what your body metabolizes, not something that indicates some historical use from several days ago. Much like the opinion in Fiesel, like you got to have the actual marijuana in your system, not some byproduct that says you used it several days ago, a week ago. So I think that's how I would address your question there. And I think that's important because, going back to Fiesel here, people need guidance. Science is always improving. Obviously, we don't always use cocaine, but if you get to the point you use cocaine, okay, when can I even drive again? We don't know where the science is going to lead us to. So I think we need clear, bright line rules here that, hey, controlled substance means controlled substance. It has to be the actual cocaine itself, not something that indicates past historical use, that has no pharmacological effect and doesn't really even impair you. I don't think that's what the statute was getting at, legislature is getting at.
Thank you, counsel.
Thank you, Justice.
Justice Clement?
How are we supposed to put what you just said together with what the prosecutor has argued regarding the statutory definition of cocaine, which includes any derivative of cocaine? They argue that includes cocaine metabolites, which are produced naturally from cocaine when it's ingested in the body. So I'm trying to see where that statutory definition and the rule that you want us to adopt here, how we make those work together.
Okay, and I think Fiesel is instructive here because Fiesel basically said in there, this metabolite of marijuana is broken down in the body. It's not a derivative.
But in Fiesel, did they discuss any statutory definition of derivatives? Because my understanding of the prosecutor's argument is that the statutory definition of cocaine does include derivatives of cocaine. So is that where the distinction is, and how do we make that track with the rule that you're asking us to adopt?
Well, the statute does say derivative, but it doesn't say metabolite, and that's what we're talking about. We're talking about a metabolite. A derivative is something that's chemically similar to the actual cocaine itself. And as the prosecutor pointed out in her brief, the body can't make cocaine. The metabolite is merely a byproduct. And as I cite to what the experts say, there's no pharmacological effect. A derivative still has a pharmacological effect.
Okay, so your argument would be that the cocaine metabolite, it does not fit the definition of derivative.
Correct, yes.
Okay, thank you.
Thank you, Justice.
Justice Kavanaugh?
Just real quick, and sort of following up on Justice Viviano's question, the distinction with Fiesel and the look back period, and is there a distinction, obviously, between the marijuana metabolite and cocaine metabolite? Isn't the question really of, is it the prosecution's burden to submit the necessary science, whether that it is akin to a derivative or it does have a pharmacological effect or whatever that is, to prove the element of the offense, and it's not the defendant's burden to prove the negative?
Yes, absolutely, Justice Kavanaugh. This is the state. They have the burden. They have to prove this metabolite is a controlled substance. Absolutely, yes. It's on them to bring the science and to come forth with it. Yes.
Because there is science that I think has been submitted on appeal that it was not submitted in the trial court, correct?
Mm-hmm. Yes.
Okay, thank you.
Justice Welch?
Yes, thank you. Counsel, just one question. I'm wondering how you respond to the prosecution's argument that basically, depending on how we find in this case, then there would never be a way to test for the presence of cocaine, or the concern that as a practical outcome of this case that could be problematic for enforcing laws. And I'm just wondering what your thoughts are on that particular issue.
Okay, thank you, Justice Wells. I guess, the same problems would apply with Fiesel, but the court still came out that way. Okay, well, how do we test for this now? Basically, I cited to in my reply brief to a few cases, and no one was published. There's a few unpublished ones. Pure cocaine still comes up in the urine, still comes up in the bloodstream. You're still going to get people testing positive for cocaine either in the urine or in the bloodstream. It's still going to happen. It's not like you run a urine test, you're never going to get a positive result for cocaine. It happens. Same thing with blood work. And I know in a lot of OWI prosecutions now, there's a lot of blood work involved in that. My own personal anecdote for myself. So this idea that we'll never ever get a prosecution, ever get people convicted of it is just not going to happen, because there's cases out there that says it comes up in the urine, it comes up, pure cocaine comes up in the urine, and it comes up in the bloodstream.
Thank you, counsel.
Thank you, Justice.
Counsel, would you like to reserve your 2 minutes for rebuttal?
Yeah, yes, I would, Justice McCormick. Thank you.
You bet. Ms. Blair, you may proceed.
May it please the court,
Wait a
Deborah
minute.
Blair, on
I'm so
behalf of
sorry, I
the
skipped
people.
Justice Zara. I'm so sorry, I skipped Justice Zara. Justice Zara, I apologize. I forgot that I didn't start with you.
That's okay. I have no questions. Thank you.
Okay, sorry, Ms. Blair, go ahead. My bad.
Okay. May it please the court, Deborah Blair, on behalf of the people, the Wayne County Prosecutor's Office, the appellee in this matter. The court has outlined 2 issues for the parties to address today. The first, was there sufficient evidence to convict the defendant under MCL 257625? And second, was the failure of trial counsel to argue that this case was analogous to People versus Fiesel, ineffective assistance of counsel. In regards to the first issue, and looking at the exact terms of the statute that the defendant was convicted of, MCL 257625 sub 8, there was sufficient evidence to convict the defendant of violation of this statute. This is because the statute requires only that the defendant have any amount of cocaine or its derivative be in the system at the time of the crash. Here, the defendant had a natural derivative of ingested cocaine in her system when her urine was tested at Henry Ford Hospital 4 hours after the crash. Statutes are meant to be given their plain and ordinary meaning, and here the word derivative contained in MCL 33372.14 obviously includes a natural derivative of human ingestion, otherwise known as a metabolite. had the statute in question only referred to the technical term analog instead of derivative, then the defendant would be correct, and evidence of the cocaine metabolite alone without more would be insufficient evidence. But that's not what the statute states. Given the statute, its ordinary meaning leads to the conclusion that evidence of cocaine metabolite is evidence of ingestion of cocaine. The statute forbidding cocaine in the system of a driver was clearly meant by the legislature to be a per se violation, and no evidence of intoxication or impairment is necessary to be convicted under the statute. That is why the offense for driving with cocaine or its derivative in the system is separated from the other alcohol-related offenses, including driving while impaired. Above and beyond that, even if a metabolite isn't a derivative, which we believe it is, the jury could still have taken this urine sample into account when deciding if the defendant had any amount of cocaine in her system at the time of the crash, which was 4 hours prior to the urine sample taken by Henry Ford Hospital. In regards to issue 2, ineffective assistance of counsel, the people would point out that there was a Ginther hearing in this case, and at that hearing, the trial court made the decision that had the trial attorney tried to make the technical distinction between cocaine and cocaine metabolite in this case, it would not have made any difference in the outcome of the case. The extension of People versus Fiesel, which dealt only with a specific active ingredient in THC, delta-9 tetrahydrocarbonol, to cocaine metabolite has never been made before making it a novel concept. Now, if this court is inclined to make a new rule, that is something that the court can do going forward. But to say that this trial attorney rendered constitutionally defective representation, that he wasn't functioning as the counsel guaranteed by the Sixth Amendment to the Constitution, just because he didn't make a novel, untested, unprecedented argument in this case that the trial court has already ruled would not have made any difference, is a step too far and presents a dangerous precedent going forward. That is because deficient performance is defined as operating below an objective standard of reasonableness under prevailing professional norms. That's according to Strickland. And under prevailing professional norms at the time of this case, there had been no comparison of People versus Fiesel to a cocaine metabolite in any published case in the state of Michigan. In conclusion, the people respectfully request that you deny leave in this case. Thank you.
Thanks, counsel. Justice Viviano.
Yes, thank you. Counsel, are you asking us to overrule Fiesel when you're on your first point that you believe cocaine metabolite qualifies as a derivative under the statute? Would we have to overrule Fiesel if we were to agree with you?
Absolutely not. I do not in any way, shape, or form say that Fiesel needs to be overruled, specifically because in Michigan, marijuana is legal to use recreationally and medically. So whereas cocaine, on the other hand, is illegal no matter what. You're not even supposed to possess it, let alone ingest it and then drive in the car. So
those are things that happened, I think, after these statutes were enacted, and I'm not sure how they would change the meaning of the word derivative in the statute. Something that, in other words, later laws could change the ordinary meaning of an earlier law at the time it was enacted. I'm not sure how that works.
Yes, the statute could be amended to include specifically a metabolite, although the regular Merriam-Webster dictionary definition of derivative is a substance that can be made from another substance. Well, in this case, cocaine makes itself in the body due to digestion into a cocaine metabolite.
Well, I'm aware. Those are the arguments that were presented in Fiesel and that were accepted in Darrer a couple of years earlier, but then were rejected in Fiesel. So, all right. Thank you, counsel.
Thank you.
Justice Bernstein.
Counsel, good morning. I want to follow up on Brother Counsel's question. What about the issue and the concern that's being raised in this case that ultimately cocaine can last in the body for a certain period of time. That doesn't mean that it was being used at the time of the incident. How do you respond to that? How should we address that? And what concern should the court have as it pertains to that?
Well, cocaine itself has a very rapid clearance rate. That's why when the person does cocaine, they get the instant high, depending on whether they smoke it or snort it or inject it. So the clearance rate of pure cocaine is pretty quick in the body. And what happens with the other products, there's several different metabolites, cocaine, but the main metabolite, benzoyl, which your liver processes. It has a half-life of 7.5 hours. It can induce seizures, even hours to days after use. It's usually cleared completely within 3 days. And that's at the cutoff rate that we used here, 300 nanograms per milliliter.
Okay, counsel, thank you.
Thank you.
Justice Clement,
No questions.
Justice Kavanaugh, Justice Welch.
Yes, thanks, counsel. I just wanted to follow up a little bit on Justice Bernstein's question. You actually talked about cocaine, and of course, that's the notion of an instant high, given the power of the drug. I'm wondering, so if it's a few days later, the metabolites are in the system, how would that be evidence that the cocaine contributed at all to an accident or the alleged crime?
Well, in this case, we don't need to show that the cocaine ingestion caused the crash, only that the defendant was responsible for the death, which obviously she was. Under the statute, we only have to have the presence of any amount of a controlled substance or its derivative. So that's why I argued it's a per se offense. You don't have to show the intoxication or impairment was the inducement for getting in the crash. You only have to show that the test shows that you had it in your system.
Okay.
And and the cocaine is, the clearance rate is so quick for cocaine that could be used by the jury as an inference that she had done cocaine shortly before the crash happened.
Well, and then Justice Kavanaugh asked counsel previously about the burden the prosecution bears in this matter then. And so it's your position is there's no burden as far as showing the effect of metabolites.
No, because it's any amount of cocaine or its derivative, and there's been we talked about this at the Ginther hearing. There is no supposition that the sample was altered or tampered with, or that the lab didn't do their job right. There's no reason for Henry Ford Hospital to have not done the correct urinalysis. So as far as that, I think the people have met their burden.
All right, thank you, counsel.
Thank you.
Counsel, I want to understand a little better maybe why we should think that cocaine metabolites are pharmacologically active. I mean, a derivative, chemically speaking, is when a compound interacts with another chemical to produce the derivative. And a metabolite, of course, is the result of a biological process. So chemically speaking, I'm not following what seems to be a pretty foundational part of your argument. Can you help me?
Well, this is what I've learned. The ingestion of cocaine, approximately 30 to 50% of cocaine is metabolized by hepatic esterase and plasma succinylchlorinesterise. That's in the liver, resulting in the formation of ecgonine methyl ester. Spontaneous non-enzymatic hydrolysis, that's talking about the kidneys, 30 to 40% results in benzoyl. Both products are water-soluble, metabolically active, and capable of increasing the blood pressure. Again, benzoyl has a half-life of 7 hours, can induce seizures, perhaps even hours to days after the last use. Now, if it was crack cocaine, and we don't know this, but if it was, that has another metabolite called methylgonadine that is more harmful than regular cocaine and theoretically can be used to create cocaine.
Counsel, I understand all that. I think, I mean, chemistry is far in my history, but I think I'm following you. But I still believe what you just described is the biological process that produces metabolites, which I think is exactly right. But the thing about a derivative is, chemically speaking, it's a compound that's derived from another compound by way of a chemical reaction, right? So that's there's the disconnect for me. Not a biological reaction, a chemical reaction.
Oh, but I think this is both. I think there's both happening.
Okay, well, what you just described was what biologically happens. So, but okay, thank you very much, Justice Zara.
No questions, thank you.
Okay, you have a little bit of time left, Counsel, if you'd like to use it.
No, I have nothing further. Thank you.
Okay, thank you very much. Counsel, you have a bit of rebuttal, 2 minutes. Mr. Kerpel.
Sorry, I was muted when I began to talk. Thank you, Justice McCormick.
Somebody has to
Just
do that each day, each oral argument day, so thank you for being the one.
Yeah. The IAC claim here, the prosecutor, this was a big hammer in their case in chief, was the fact that they argued Ms. Stock was high on pure cocaine itself and had pure cocaine in her system. It really is a big part of their case as it related to all the charges. So in that regards, that was left unchecked by her trial counsel. So in that regards, I think this court should not only vacate the convictions for the operating offenses, but also order new trial on remaining offenses. And that's all I wanted to get to, Your Honor. Thank you.
Thank you. Any additional questions for Mr. Kerpel? Thank you both. The case will be submitted.